housekeeping-related notes. At the close of the session, we will have box lunches available right outside this room.
We already got them.
Well, that's not a lunch, I'm telling you. That's a parting gift. You're free to certainly bring them back in here, and certainly I'll be eating in here. But obviously, some folks I know have earlier flights, and if you need to head off to the airport and want to take that with you, please do. I think that was the only housekeeping item I had, but now we're going to turn to a.
Jonathan, are there buses?
There's a shuttle. It was in Nancy's last email to everybody. I think there's a shuttle that's coming. That's for the next from like 12:15 to 3:15. I think it's consistently going back and forth.
First one is supposed to leave at 12:15, and then we'll continually make loops.
So what? So 12:15, sort of 1:15 would probably be about the next.
Yes, I would assume about that.
Is that how long it takes to get?
Yeah, it's about 25 this time of day, about 25 minutes. So assume it'll be back in an hour.
Okay. So.
But now for our final session on the very non-controversial topic of pleading and the court's Twombly and Iqbal cases, which, as Brian notes, are on their way to becoming among the most cited Supreme Court decisions ever.
That's right.
Which is really quite remarkable, and I think certainly reinforces the importance of civil procedure to those of us that know very little about it and don't teach it. But without any further ado, I'm going to turn it over to Brian Fitzpatrick, who's an associate professor at Vanderbilt, who will tell us what we should think about these pleading cases.
Thank you, Jonathan, and thank you to Case Western for this lovely conference. I've had a pleasure meeting all of you here. I do want to talk about what I think, as in a very biased way as a civil procedure professor, what I think are the most important cases for business thus far in the Roberts Court, and that is the Twombly and Iqbal cases, which will affect every case that is filed in federal court, every civil case, and or has the potential to affect them. And so I think that the implications for business are quite profound, and most commentators do as well. So I'm going to spend a few minutes talking with you about them today. As you know, I'm sure we're all, as we all remember from civil procedure, in 1938 the rulemakers put in what is called a notice pleading regime, and basically what this meant was you didn't have to do very much if you were a plaintiff in order to get your case into federal court and to get access to discovery. The purpose of the pleading was simply to put the defendant on notice of the claim you had against him, so the defendant could prepare a responsive pleading and plan for discovery. It was very little was required. The forms in the back of the rules are often 1 or 2 sentences long as the sample complaints. So plaintiffs didn't have to do much in order to file a complaint and then get access to discovery. The Supreme Court said over the years, and the rulemakers envisioned, that the pleading stage was not the place to learn about the facts of a case. You did that during discovery. And the pleading stage was not the place to worry about the merits of a case. You did that on summary judgment. This was the regime the Supreme Court lived in for 70 years, and the height of the regime is the famous Conley v. Gibson case, where the Supreme Court basically said that so long as you've given the defendant notice of what you're suing him about, so long as you can imagine a set of facts consistent with what you've said in the complaint and consistent with the elements of the cause of action, then you can stay in court and you can get discovery from the defendant. That was the Conley v. Gibson rule. It reigned in the Supreme Court for 70 years or for 50 years thereafter. The Supreme Court several times over the years would unanimously reverse lower courts that had tried to require more of plaintiffs. It seemed to be something the Supreme Court was in agreement on, that notice pleading was the regime of the federal rules and the regime that we had to abide by in federal court. So this came to an abrupt end in 2007. So and how abrupt it is really remarkable, because in 2002, when I was clerking, the Supreme Court decided a case Cerkowitz. It was unanimous in reversing the Second Circuit, which had said that if you are complaining about employment discrimination, and pretty much all you say in the complaint is that you were fired because of your race or national origin, as it was in that case, Second Circuit says not enough. You got to do more, and the Supreme Court said no, you don't have to do any more. You told the defendant what was going on, basically, and now let's sort it out in discovery and on summary judgment. Well, just 5 years later, in Twombly, the Supreme Court decides a case where they effectively throw out the notice pleading regime. And it was an antitrust case, and we heard a little bit about it yesterday from Tom. I'm not going to get into the antitrust details, but the bottom line was, in order to state a claim under the antitrust laws, you have to show an agreement to restrain trade. And the plaintiffs in Twombly alleged there was an agreement among the defendants, some telecommunications company, to restrain trade. And under Connolly v. Gibson, you could certainly imagine a set of facts consistent with the complaint and with the antitrust elements. You could imagine these telecommunications companies getting together and coming to an agreement. And so it seemed like under Connolly that this should be enough. And the Supreme Court said, well, maybe under Connolly it would be enough, but we are retiring the Connolly rule. We are retiring the Connolly rule. Pleading is no longer just about putting defendants on notice of the claims. They can file responsive pleadings and plan for discovery. The Supreme Court said pleading also serves another purpose, and the other purpose is to weed out claims that are not sufficiently meritorious such that they deserve to get access to discovery. The Supreme Court said not only must you put defendants on notice of the claims against them, but your claim you must put enough facts in the complaint to show that your claim is plausible, that it has a plausible chance of succeeding, that there's a plausible chance of turning up evidence in discovery to substantiate it. In the antitrust case, they said a plausible claim would be one where you allege one of these plus factors, that Tom mentioned yesterday, I believe, or they said you could have put in some details about when this agreement took place, where it took place, which conference room they were in, who was there. You could say things like that, or you could allege a plus factor that made it that made it more likely that there was an agreement here to do this rather than just parallel conduct. So this was a big change from what we had known before, and the reason why the court was making the change, they said, was basically discovery is expensive. Twombly was a nationwide class action involving consumers of telecommunication services. It included something like 90% of the American people as class members. It was going to be very expensive to go to discovery, and the Supreme Court said, we're not going to let you get to discovery unless we think there's a decent chance that this complaint has some merit, because it's so expensive. It's expensive to defendants. They're going to have to produce a lot of documents. You're going to waste a lot of people's time. It's very expensive, and we're not letting you get to that expensive stage in litigation unless we have some assurance that it's worth it. And why not? Well, because it's rational for defendants to settle suits in order to avoid litigation costs. And so when discovery is expensive, that means that litigants will rationally settle suits to make them go away to avoid discovery costs. So that means if you don't look at the merits, the court says, at the pleading stage, then cases that have no merit whatsoever can extract extravagant settlements from defendants because defendants want to avoid paying for discovery. That's not good litigation policy, the court says, so we're going to ask from now on that complaints have a chance to succeed, that they're plausible before we get to discovery. So this was stunning. It was stunning to most commentators because, as I said, for a very long time the court had been so solicitous of the rights of plaintiffs when it came to pleading. Most commentators hoped that the court's ruling was a kind of a Bush v. Gore. It was a one-time thing. It was special circumstances. You had an antitrust case. It was a complex class action. It was very expensive discovery. There were such a big case. So most commentators thought that it was going to be limited to a very narrow context, and we would go back to Conley v. Gibson and everything else. But a couple years later, the Supreme Court clarified this was not a one-off, that this is now the rule across the board in civil litigation in federal court. There was the Iqbal case. Iqbal involved, it was a civil rights complaint against some high-level federal officials who were responsible for implementing anti-terrorism policy. They detained and roughed up someone who was a Muslim. He sued and said that he was detained and roughed up on account of his race and religion, the same thing that Cerkowitz had alleged in 2002. And the Supreme Court said, that's not enough. That's not enough. It's not plausible. There's all kinds of reasons we think that you were detained and roughed up other than your race or religion, and you haven't given us enough to think that race or religion was the reason, therefore we're not going to let you get to discovery. And the Supreme Court said it's not just antitrust cases, it's not just cases where discovery is expensive. It wouldn't have been very expensive in Iqbal in terms of money, it would have been expensive in terms of time. It was high-level government officials, Ashcroft and what have you. And so with this pair of cases, the Supreme Court made it clear that it's a new day as far as it's concerned when it comes to pleading in federal court, that district court judges are now deputized to go forth and decide which cases are and are not worthy of getting discovery. And the way that they're supposed to do that is by asking whether, at the time the complaint is filed, the claim set forth therein is plausible. So, commentators have not been happy with this decision, and it's very curious to a lot of them why the Supreme Court has made such an abrupt switch. Again, Cerkowitz was a 2002 case unanimously suggesting something quite contrary to Twombly and Iqbal. And so commentators have asked themselves why? Why now? Why has the Supreme Court changed course? And one of the things that I suggest in the paper, and this is just kind of a fun speculation, is maybe the difference was Chief Justice John Roberts. As I say in the paper, no one on the Supreme Court prior to Roberts, at least on the Cerkowitz court, had practiced civil litigation since the 1970s. These were people that were, the last time they practiced, was before computers, let alone all the Ediscovery that I'm going to talk about in a minute, has flooded the litigation process. And so it may not have been apparent to these justices who hire law clerks who are right out of law school and themselves haven't practiced law yet, just what modern civil litigation had become. And maybe you have someone like John Roberts, who until 2003 was representing corporations at a big corporate law firm in Washington, D.C. Even though he was an appellate litigator, surely he saw the boxes of discovery that his associates were going through in other cases. And maybe he had something to do with the very abrupt and unexpected shift in the court's thinking about whether the cost of discovery justified some kind of heightened pleading regime. But putting that aside, most commentators have concluded that what the Supreme Court has done here will be revolutionary for the federal civil system. They have concluded, for the most part, that what the Supreme Court did was unnecessary, that it was unnecessarily solicitous of corporate defendant interests. And they have complained most vociferously that what the court did was a usurpation of the rulemaking process, that they basically rewrote Federal Rule of Civil Procedure 8, and they did it without going through the normal channels. And when you add up all of these claims, what you get is what some people have called here conservative judicial activism. So this is one of the cases where people have really linked in to the notion that the Roberts Court is a business court. This is really Exhibit A to a lot of people that make that claim, that they're willing to do whatever it takes to help corporate interests, that they are conservative judicial activists. And what I'd like to do in the couple minutes that I have here is to give you some reasons why I think a lot of this criticism is harsh, not all of it, but why some of it is too harsh, and then to ask a question about whether if you take the court's concerns at face value, whether there's a better mechanism to accomplish what the court wants to do in these cases. So first, starting with some of the criticism, is this going to cause a revolution in the federal civil system? Well, I think it is certainly quite revolutionary as a matter of Supreme Court jurisprudence. As I've said, the court really changed courses from Cerkowitz to Twombly and Iqbal. But I don't think it's going to be revolutionary beyond what the Supreme Court does, because there has been very good work in recent years showing that lower courts were ignoring notice pleading for a very long time already, which is why the Supreme Court would occasionally have to reverse them. In Leatherman and Cerkowitz and cases like that, they'd unanimously reverse. Lower courts had a practice of requiring more from plaintiffs dating back many, many years. Before Twombly was decided, empirical research has shown that 50% of motions to dismiss were granted. That's a very high number, much higher than most commentators would have expected in light of notice pleading. Although, there are law and economics theories on why every piece of litigation should always end up in a 50-50 outcome. I think most commentators were surprised by that 50% number. And when people look into the cases on an individual basis, they find heightened pleading requirements of one kind or another. There's a wonderful pair of articles by Christopher Fairman laying that out. And the empirical evidence after Twombly has shown that the rates of motion to dismisses being filed and granted are not that much different from what they were before Twombly. So there's a notion that this has been going along already. The lower courts have been doing this for a long time, and many of the reasons that Chris Fairman found that lower courts were doing it were to protect defendants against abusive discovery. So in some respect, the Supreme Court here is caught up with what lower courts have been doing for a long time. And this does not surprise me, to see this phenomenon of a Supreme Court ratifying after the fact a practice that had already been adopted by lower courts. It happened, many people believe, with summary judgment. In 1986, I know in the paper, the Supreme Court decided cases that changed the summary judgment jurisprudence, making it much easier to grant summary judgment. A lot of people thought this was a giveaway again to corporate defendants. The empiricists demonstrated that district courts had started granting summary judgment motions in higher numbers before the Supreme Court's opinions, not after. The Supreme Court caught up to lower court opinion. This is not surprising because lower courts are much closer to the realities of contemporary litigation. They understand the burdens of discovery arguably more than people who haven't practiced law since the 1970s do. And therefore, it's not surprising that when there is a change in the factual background of litigation, i.e. a change in how much discovery is costing, that district courts will respond. It's also true that district courts have docket pressures that Supreme Court justices don't, that they decide a lot more cases than Supreme Court justices do, and it's not surprising that their incentives would be to find ways to get rid of cases more readily on motions to dismiss or on summary judgment. But for whatever reason, I'm skeptical that this is going to cause too much of a revolution in the system as a whole. Is this conservative judicial activism? Well, it's true. I think the Supreme Court changed its interpretation of Rule 8. I think the Supreme Court did basically change the meaning of Rule 8, at least as far as it was concerned. Normally, changes like that do go through the rulemaking process. But the rulemaking process is a judicial process. There's a judicial conference that gets together and they scrutinize changes to the rules and they make recommendations to the Supreme Court, and then the Supreme Court promulgates rules. They go to Congress, and Congress can pass a law to stop a rule from going into effect if they want to. They have 7 months. But the process really is a process in the judicial branch. And so, although the Supreme Court did in some sense circumvent that process, I don't think it's the kind of stuff that's really made of the judicial activism that usually gets us upset. I mean, here the Supreme Court has basically usurped the judicial branch's authority. They haven't stepped on the toes of Congress, or haven't interpreted the Constitution in a certain way. They haven't struck down statutes. They haven't invalidated rulemakings. This is not the kind of judicial activism where one branch usurps the authority of another branch. All the Supreme Court has done is circumvented the judicial branch's own procedures. I don't think that that deserves to be lumped into the same category of judicial activism that we normally think of. Would it have been better in some procedural sense to go through the normal channels? Perhaps. But I don't think that we should lump it in with the same kind of cases that usually get people so excited about activism, striking down legislation, and what have you. And I'll also note, the Twombly decision, anyway, included two of the liberal wing in the majority. It was written by Justice Souter. Justice Breyer joined it. Those are the two most business-friendly justices on the left, granted. But it's a little bit harder to make the case that this is conservative judicial activism when you have a 7-2 decision in Twombly. Now, there's some sense that maybe Justices Souter and Breyer didn't know what they were doing in Twombly because they switched to the dissent in Iqbal. Iqbal was 5-4. But nonetheless, at least in these expensive cases, there seems to be some sympathy among Souter and Breyer that it's too easy to get to discover. Now, what about the notion that these cases were unnecessarily solicitous of the rights or the interests of business? And here I have to disagree most with commentators. Things have changed since 1938. It is hard for me to believe that the discovery that goes on today is not radically different and radically more expensive than it used to be. We have something called Ediscovery today. Because corporations are so big now, because they can store information electronically, the amount of data that you have to sift through for relevancy, then review for privilege, is enormous compared to what it used to be. There are gigabytes and gigabytes and gigabytes of documents you have to sift through. And again, anyone who's been in a law firm in recent years has seen the boxes in the conference rooms with dozens of associates sifting through them. Nowadays, I'm a little dated. It's been 7 years since I practiced. Nowadays, they're using compact discs and what have you. Some of my friends at the big law firms, they work from home and they spend 14 hours a day sifting through the PDFs on their computer. I mean, it's costing people hundreds of dollars an hour to review thousands and millions of pages of documents. This was not the way that things were in 1938. So it's time to think about whether we have struck the right balance between plaintiffs and defendants. When the discovery that defendants are on the hook for when cases pass a motion to dismiss is orders of magnitude more expensive than it used to be. I will note that there, what I've told you about orders of magnitude more expensive and what have you is entirely anecdotal. There's not good empirical evidence to substantiate what I've said. There's not good empirical evidence at all, I think, in the realm of discovery. I talk a little bit in the paper about some of the empirical studies that have been done on the cost of discovery. Since I wrote the paper, there's been an update to the Federal Judicial Center's 1997 survey. They have a 2010 update to that, where they try to, they take a random sample, not so random sample, it's weighted in some ways, of cases that terminated in 2008. And they sent out thousands of questionnaires to the lawyers involved in the case to try to glean what they thought about discovery. And the numbers that these FJC surveys come up with are just shockingly unrealistic. I don't buy any of it. In the paper in 1997, you may remember, my paper said, the FJC survey said that the median litigation costs for defendants in a federal civil suit was $15,000. That's the median litigation cost, entire litigation cost for defendants. Half of that, on average, was discovery. So in 1997, roughly $7,500 was being spent on discovery in the typical case in federal court. According to the 2010 results, so we've got 13 years under our belt now in the meantime, the median litigation costs for defendants have gone from $15,000 to $20,000. The percentage of it attributable to discovery is now down to 27%. So you've basically taken your discovery costs from $7,500 in 1997 now down to $5,000 in the typical case in 2010. I just don't believe it. I just don't believe that in a typical case in federal court, only $5,000 is at stake when you go to discovery. And I'll say that, I'll say two things about that. Number one, it may very well be the reason why those numbers are so low is because people are settling cases to avoid discovery costs. And so we don't know how much they would have paid had they not settled their case. That may be one explanation for what I think are radically unrealistic numbers. Secondly, it may be the case that the federal courts are filled with lots of little cases that I don't appreciate because I worked at a big corporate law firm. And that it's only very few cases that involve the kind of discovery that make people concerned about the nuisance value of a lawsuit. If that's the case, I don't think Twombly is going to have disastrous consequences in the areas where it shouldn't have consequences. Because if the case is so small that you're talking about avoiding $5,000 of discovery, I doubt anyone's even going to bother to file a motion to dismiss to begin with. I mean, it hardly makes sense asking a lawyer to file a motion to dismiss at hundreds of dollars an hour if you can get through discovery for $5,000. And so I think if that's the case, Twombly is probably only going to be an issue in cases where discovery is expensive to begin with, the non-$5,000 cases, the cases where electronic discovery is substantial and a lot of nuisance value is at stake. Okay. So in my own view, it is time to revisit the 1938 balance between plaintiffs and defendants. And what I'd really like to do is to spend some time with you today, because I've just started thinking about this myself. Spend some time with you thinking about whether pleading standards are the right way to respond to the changes in discovery costs that I think that we have seen since 1938. Are pleading standards the right way to reset this balance? With pleading standards, judges decide whether a case is worthy of discovery or not, and it's an all or nothing approach, as I note in the paper. If you pass the standards, you get all the discovery that you're entitled to. If you don't, then you get nothing. And it occurs to me that we might do a better job of making wise decisions about what cases should go to discovery and what cases should not if we change to a fee-shifting rule. A fee-shifting rule where plaintiffs are required to pay for some or all their discovery requests. Fee-shifting rules place the incentives to decide whether a case should go forward to discovery in, I think, an actor that can make a more responsible decision about whether the discovery is worth it. The judge doesn't know about the cost, doesn't know about the benefit. The plaintiff, if you've got to pay for the discovery request compliance, has an incentive to be very careful about what he or she requests. If the plaintiff doesn't think the discovery is worth it to his or her case, the plaintiff's not going to ask for it. Whereas now, the more the plaintiff asks for, the greater the settlement value of the plaintiff's case, because there's more litigation costs for the defendant to avoid. So I think putting the incentives to be more careful about discovery with the plaintiffs would lead to more responsible decisions about what kind of discovery can be had. In addition, a fee-shifting rule seems to be more tailored to the appropriate discovery, because it's not all or nothing. I mean, you can have a little bit of discovery, you can have a lot. It depends on what the plaintiff thinks is worthwhile. And so I think moving to a different type of regulatory device, from pleading standards to a fee-shifting rule, might be appropriate. Now, there's a number of different types of fee-shifting rules one might imagine. I mean, one rule is, plaintiff pays for everything. Plaintiff pays for every response to his or her requests. If you think that's going to be too discouraging to plaintiffs, a plaintiff could pay for part of it, half of it, split the cost with the defendant. Maybe you could, trigger this fee-shifting rule based on the outcome of summary judgment or the outcome of the case. So if the plaintiff loses the case, then he's got to pay for the discovery he or she asked for. If the plaintiff loses summary judgment, if nothing came up during discovery and there was no material dispute as to fact and the plaintiff lost summary judgment, maybe then the plaintiff should pay. You could even imagine rules, I think, that are, in my opinion, unimpeachable improvements over the current system from, I think, a social perspective. You could have a rule where you have this plausibility pleading standard But then you say to the plaintiff, we're going to dismiss your case as not plausible unless you want to pay for discovery, and then we'll let it go forward. You get to decide. So in that case, we've combined the two devices. And so I'm just curious what people think about whether some sort of fee-shifting rule would help us make better decisions about whether discovery should be had or not, and what the consequences of some of these fee-shifting rules might be. Will it lead to fewer cases being filed? What kind of cases being filed less often, et cetera, et cetera? I mean, because one of the challenges here is, a lot of times when you file a complaint, you don't know what's in the defendant's files. You don't know if you've got a case or not. You think you might. You've got reasons to believe you might, but until you see what's in the defendant's files, you don't know. So when we screen out cases at the outset for not knowing enough, we're screening out some meritorious cases. Sometimes these people are going to find things in the files to vindicate their suspicions. So we might be better off with a rule that allows them to have access to discovery if they're willing to pay for it. But those are just some things I'm hoping you might help me think through.
Okay, we've got a lot of folks on the queue. Gerard?
Yesterday, Professor Pritchard said he's a Supreme Court clerk in law. Well, I'm a economic damages litigation consultant in law. And if there's anything that I've gathered is extremely ambiguous, is how much did something cost? How do you determine what discovery costs are in a way that is not susceptible to manipulation intended to deter meritorious plaintiffs?
Well, one of the difficulties is if the plaintiff has to pay for the cost of discovery, for example, the defendant has very little incentive to make it cheap, right? So don't put the first-year associate on document review. I want the partner reviewing the documents, and so that's a problem. It's a problem because the plaintiffs may not know ex ante what it's going to cost to do the discovery, and therefore they may not know whether they want to ask for it. And secondly, you give a lot of power to the defendants to shape what it costs, moral hazard problem, which is why it may not be optimal to have a rule where plaintiffs pay for everything. It may be optimal to have a rule where people split the difference. But the bottom line is we have to have some way to measure what these things cost. At the very least, we've got billable hours. When you do these lodestar cases, you ask the lawyer to submit their timesheets to the court, and most people think those are inflated, and I'm sure these discovery timesheets would be inflated as well to some extent. But the lawyers have an ethical obligation to be at least somewhat honest, there's no easy way to value these things. But I think we have to do the best we can, and doing the best we can has to be better than doing nothing at all, I guess is what I would say. I don't know if that's very responsive to your question.
Jesse?
Yeah, I enjoyed the paper. I also teach civil procedure, but my scholarship is not in civil procedure, which means during semesters like this one, when I'm not teaching civil procedure, I can't actually remember anything about it. So let me just start with that caveat. But I agree with your point that the change that Twombly and Iqbal instituted was maybe not as dramatic as some commentators suggest. I actually agree that lower courts were applying a more heightened pleading standard before this. But I wonder if it was the same kind of heightened pleading standard. You seem to imply that they were doing what Twombly and Iqbal now require, whereas I'm not convinced that they were actually doing anything like plausibility pleading. I'm not certain. I think it was more that they were requiring a certain level of specificity, a level of detail, specifically detail allegations that might pertain to each element of a cause of action, for example, that the plaintiff is alleging, but not this. It was more about the level of detail and not about the kind of information that had to be in the complaint. That somebody had to be convinced by it. I mean, that's my sense. And again, I know that this is but I would just like to hear more maybe about why you or whether you see it as being the same pre and post. I have just a couple of other quick comments. The other one is that you're focused on the cost of discovery, and I can see that you're responding to this claim that these are business-friendly decisions, and so maybe that's why you're focused on the cost of commercial litigation. But of course, with Iqbal, the court expanded beyond the expensive antitrust context to civil rights cases, right? Where discovery often is not, as you acknowledge, right, as expensive. They don't tend to be as document intensive unless they're kind of class actions or things like that. And also the defendant is not usually paying, I mean, it may or may not be paying lawyers on an hourly basis to do the discovery, right? So I just, you know, since you do mention that these rules are supposed to be trans-substantive, and in fact, you know, the court proves that it meant what it said, in a trans-substantive way, it might be worth thinking about whether or not this focus on the cost of litigation makes as much sense in the civil rights context, for example. And then finally, kind of related to that point, your fee shifting solution, I just was wondering whether, I mean, isn't it the case that judges could already require fee shifting in the discovery, if they felt, I mean, certainly there's discretion under the Ediscovery provisions, but even in the regular Rule 26 undue burden portion of that rule, the judges can impose conditions to protect defendants against undue burden. So I'm wondering whether you have thought about in what way it might make sense to have, if there's a reason why it makes sense to have a set rule or to, you know, affirmatively shift the default rule as opposed to leaving this up to the discretion of judges in individual cases.
Those are all great points, Jesse. I think, first of all, I think you're probably right that the kind of test that the lower courts had been using to heighten the pleading requirement pre-Twombly was of a different sort than the Twombly test. I think they were motivated for similar reasons, or they were similarly motivated. But I think you're right. And if you go back to the Fairman studies, I don't think you'll see the word plausible being used in any of the lower court opinions that he references. And so I think you're right. Now, functionally, is there a difference? You know, when you say, I want to see a lot more specificity of what you think happened, is that going to end up being pretty much what the plausibility standard results in? That before I think a claim is plausible, I need to know more detail. I mean, again, in some cases, maybe in some cases not. In the case of the I think, you know, Twombly, the antitrust context is a perfect example. You know, one way it could satisfy plausibility is adding one of these plus factors to show why you think that this wouldn't have happened through parallel conduct. That's really not a specificity thing. On the other hand, the court said you could tell us when they met and where they met and who was there. That is a specificity thing. So I think that in some cases they'll be functionally equivalent, but I think you're probably right. In other cases they won't be.
Iqbal, maybe not.
Yeah,
right.
Yeah. So Iqbal is a case where discovery costs would not have been high. I think that's true. And so why did the court do it there? You know, I think maybe the court felt like, well, we have no choice because these things are supposed to be trans-substantive. Maybe we have no choice. On the other hand, maybe the court thought that discovery is burdensome not only in terms of money, but also in terms of who the people are that are going to have to be deposed and what have you. You know, John Ashcroft, his time is important. But I think, you know, it is a good point you make about these government civil rights cases. They are different types of cases. And one of the things I noted in the FJC study, federal civil litigation that I mentioned, a lot of those cases are civil rights cases. So I don't know if that's driving down the litigation costs in some way.
I don't know how they,
I'm not sure how they're measuring a government lawyer.
Yeah.
I'm just not sure. But a lot of them are civil rights 1983 cases. And so that's something I need to find more about, honestly, because maybe that is an explanation for those low numbers. And you're also absolutely right about there is a limited ability of judges now to shift fees during discovery. There is a notion that judges aren't doing it, even when everyone seems to think it might be appropriate. They do it a little bit more often on e-discovery. But there is a notion that maybe if you institutionalized it through an automatic rule, that you would have more success in reaping some of the fee-shifting advantages. And that is, if you think that fee-shifting is superior to pleading rules, why shouldn't we have it all the time? Why should we leave it up to the discretion of the judge in this case or that case? Again, if you doubt the incentives of judges to begin with, the incentives and informational position of judges to begin with to make good decisions about which cases should go to discovery and which cases should not, should we also doubt their incentives and information when it comes to making good decisions about when fees should be shifted and not? I don't know, but I do think that's something that is worth more thinking about and more discussion, Jesse. Thank you.
Two questions that are, I hope, related. First, If we go to a system of fee shifting for discovery, don't we run some risk that we will now generate satellite litigation about the cost of discovery, just as we have done with attorney's fees under fee shifting statutes? Now, to some extent, the Supreme Court's endorsement of Lodestar has limited the grounds for the satellite litigation, but that still leaves plenty of room. So one question to think about if you were to craft a proposal of this sort is, how do you deal with that possibility? More generally, a lot of the attorney's fees and fee shifting cases have been decided against a background that in the United States, each party bears its own costs, and the Supreme Court, for example, going back to Alyeska, hesitated to adopt something that looked like the English rule. To what extent are you taking a big step down the path toward adopting the English rule, and to what extent do you need to anticipate objections of that sort, or maybe to what extent do you have to think about whether you are actually proposing something that would have much more profound implications, whether that's a basis for objection or not, just to get a sense about where we might be going?
No, I think both those points are terrific, Jonathan. I think you're absolutely right. This is a step towards the English rule, and I think it's worth thinking about the literature in that area as well as the objections that have been raised in that area. And Martin Reddish actually has a wonderful paper up on SSRN right now talking about does it make sense that we've turned our back in this country on fee shifting, specifically in the context of discovery. He doesn't compare it to pleading rules. But so I think you're right. I think it's worth thinking about in a more systematic and general context whether the concerns about and the benefits of the English rule carry over to this context. Or is there something special about discovery maybe that it makes it worthwhile to have an English type rule here, even though it doesn't other places? So I think that's definitely worth exploring. And I think you're absolutely right. And I should look into what the satellite litigation in the Lodestar cases looks like, because you're absolutely right. You're going to have disputes over, is this bill from the defendant reasonable? Are these, asking the partner rather than the associate to do document review, was that reasonable? And are the rates they're charging reasonable? And are they padding the bill? There's going to be questions about that. And it would be interesting to look at how much litigation ensues in the current Lodestar cases to see how big of a problem it's going to be. I think those are both excellent points, and I thank you.
Tom?
Yeah, I got on the queue before you made your very first comment, Brian. You sort of made the point, but I think the moral hazard problem with the fee shifting is just massive. And I say that having done Ediscovery, a lot of it. I was just always amazed at my fellow associates with the difference in the amount of time it took various people to go through the same number of boxes of documents. We also had, with Ediscovery, I'm sure the technology has gotten better, but we had this thing called Dolphin Search that we could use to look at emails. You've got gazillions of emails, and you could enter keywords. And if you paid for this, in responding to requests for documents, if you were willing to pay for this, that would cut down on your time and going through people's email. I can see how a court could evaluate the reasonableness of document production fees if they're just looking at the billable hour of the person doing the work. I mean, if you've got a senior partner doing this stuff, then there's a problem. But it's really hard to say, to look at the number of hours someone spent, responding to requests for documents and say that's unreasonable. You don't know how much they had to look through to respond to the request. So I think that's a really big problem. A question I had, since you've already addressed that point, now I get to ask another question. I think that one of the reasons people are so up in arms about this notice plus plausibility pleading standard is that they think that when the court says you must plead a plausible claim, that means you must convince the judge that the stuff that you allege might have really happened. In other words, plausible equals credible. And that's, I don't know Iqbal at all, but that's certainly not a proper interpretation of Twombly, I don't think, if given the antitrust context. I mean, that's a case where what's alleged are facts from which competing inferences can be drawn. And so what the court's saying is when your claim is based on facts from which competing inferences may be drawn, you have to say something that suggests the inference that you're pushing is the right one. It's and this made me think of the case, I can't remember the name of the case. The Tell Labs case that says that deals with this issue with respect to scienter. Well, something I just thought about is what's really weird here is that the court says in that case, which is under the PSLRA, which posits a very heightened pleading standard, that if you have equally plausible inferences, that's enough. And here they've said under notice pleading, it's not a heightened pleading standard, they seem to be saying that you have to show that your competing inference is the more plausible one. My basic question, I guess, is do you think we'll see a case to sort of deal with the folks that are saying, that are equating plausibility and credibility? Is that fair is that a fair interpretation of these cases? And if not, do you think we'll see a case from the court that says, what we mean is, if your complaint is based on facts from which competing inferences may be drawn, you have to negate the other inferences?
I think that's what the court does mean. Maybe there are different ways to state it, but I think what the court is saying is, so you've painted a picture. What percentage of the time when you paint a picture like that is the thing that happened, the thing the defendant can be liable for? And what percentage of the time when things like this happen is it something happened where the defendant can't be liable? And the Supreme Court's basically saying we want to know enough to know that the percentage chance that the liable thing is behind this is plausible. We want the percentage to be a plausible percentage. And whether it's more plausible than not, I think that is one reading of Twombly, which is it is very curious. It's higher than the PSLRA standard. And I should note that Adam pointed out to me during the break that we do have something of a trial run with heightened pleading standards in the PSLRA, and I need to learn more about that context to make some assessment of how successful the PSLRA has been in regulating access to discovery and court. But it is a good analogy to look from and good lessons to be learned from that context. But I think the test is as you think it should be. And I think when we say credible, I think what we really mean in a lot of these contexts is simply that the likelihood is strong enough that it's worth figuring out whether that's actually what happened, that it's not just a 1 in 100 shot. So every time you see people, when you see the airlines change their prices on the same day or the same week, what percentage of those times are they doing it pursuant to an agreement, and what percentage of those times are they doing it just because they saw what the other guy was doing and they said, well, let's do it too. And if, making that kind of assessment, and if the percentage is high enough to go forward, I think is the analytical way to look at what the court is doing in these cases. On the moral hazard point, I think it is a big problem, and I think it does concern me. And I'm wondering, can we do anything about it? Tom, I don't know. What do you think? I mean, it seems to me that we have a moral hazard problem on the other side as well. Because when plaintiffs don't pay for the discovery they request, they're going to request too much of it. So there's a moral hazard there. And which moral hazard is worse? I'm not sure. What about splitting the costs? If defendants have to pay for half, will they be careful enough? If defendants have to pay for everything unless they win summary judgment, will they be careful enough? Do you think there's any hope in dealing with the moral hazard, or are we out of luck? What do you think, Tom?
Don't we get to ask?
25 more minutes.
Yes.
I don't know. I mean, yeah, there's definitely a moral hazard problem on the other side as well, for sure. Although, when you make overly broad discovery requests, it bites you in the butt.
It's true.
You end up,
Having to look at them all.
You're buried with and that, I mean, that's the thing you do as a defense lawyer sometimes. You're like, if you've got a hot document, make sure that hot document is, you pass it over in 17 boxes so that they're unlikely to notice it. So the moral hazard on that side, I think, is
self-regulating.
To some degree,
Yeah.
a little bit. But I don't know.
Yeah, thank you.
On that point, are there possible lessons to be drawn from FOIA? I mean, theoretically, make a FOIA request. Academics always, I assume, always file the waiver or the request to not have to pay costs. But certainly, a private company that files a FOIA request with the federal government typically is going to have to pay for the costs. I mean, it's not really the full costs in terms of the government time and stuff, but there is, at least theoretically, for those who can afford to pay, a degree of cost shifting under FOIA to prevent requesting too much. Now, obviously, there are other aspects of FOIA which you're not talking about replicating. I don't know if there are any lessons there. And certainly, there's a whole literature about why FOIA doesn't do what it's supposed to do. But
That's a great suggestion. I was not aware of that under FOIA. I thought the government picked up a tab every time. So
if
that's
you're a nonprofit,
that's great.
If you're Mal, the rules. If you're indigent, if you're a nonprofit,
Personal records.
yeah, personal records about yourself. There's an exemption
Journalists.
for it. Yeah. So basically,
They only include the search costs. They don't include the review costs. I mean,
Right.
there's a complicated system, and there are cutoffs. Point being that it's not the kind of thing that the Supreme Court could have issued in a rule, which is a process-based question, which well, anyway, I have something else to say too.
yeah.
So I like the paper a lot, and it's especially as somebody who clerked on the district court, it's especially useful, I think, to have articulated in writing the sort of "are you kidding me" standard that I think district court judges will always apply to every complaint they see, and will never not. That is really hard to defeat with doctrine, and I think the way that Conley versus Gibson was applied is an example of that. I mean, it struck me that you're kind of saying that there's a choice of gatekeepers here, and one way to think about Twombly and Iqbal is that the court is moving the gatekeeper for what kind of complaints proceed to discovery function away from plaintiffs' lawyers and towards judges. And it also strikes me that what you're saying is that maybe it should go back to plaintiffs' lawyers, and they would be better gatekeepers if they had to think about the fees that would be paid in discovery. So that all strikes me as kind of interesting, and it also strikes me as a bit like Daubert, and I wondered if, one of the things that motivated this change, it's kind of hard to tell a story that makes sense with the timing, but one of the things that motivated this change is, experience with and like for the way that Daubert's working, where the judges became gatekeepers over certain kinds of expert testimony. So the part that I disagree with your paper about, and I wondered if you had something to say about this, is that discovery, especially now that it's e-discovery, sucks. I don't know if I buy that. I mean, e-discovery ought to make discovery cheaper. You can imagine that the world hasn't changed too much between 1992 and 2002 or whatever, except that e-discovery came into the world. But otherwise, the big corporate defendants were under exactly the same kind of, sort of discovery obligations. And I don't see any reason why 2002 response to discovery requests ought to be more expensive. In fact, with e-discovery, and George Geis has some stuff on this, and document management systems and all that kind of thing, it might be cheaper. And in any way, for the big corporate defendant cases that you're most worried about, and you think that maybe the court's most worried about, I mean, litigation is often really very cheap. There's some bet the company cases, but if you're responding to, I mean, it's easy to exaggerate as lawyers, especially lawyers who work at private firms, how much legal fees take off the bottom line, because that's why high-end law firms keep getting hired, because these costs are a tiny quantity of the assets that these firms, whatever, the revenues that these firms make. So, so I don't know that really IBM sits there and thinks, you know what, no dividend this quarter, we're paying our lawyers too much. I just don't think that's, I mean, I don't think it's, yeah, so anyway, so that's something to think about, and that's why I'm not sure that the discovery has changed so much, given that the obligations haven't and that Ediscovery is such a bad thing.
Those are excellent points, David. I appreciate them. It's very interesting the way you put it about switching the gatekeeper back to the plaintiffs. I guess it is true. I guess under the notice pleading regime, we basically had a world where plaintiffs' lawyers got to decide what cases got discovered, at least if you took the regime seriously, because there was very little required. And now the court says let's make it judges making those decisions, and I'm saying let's bring it back to the plaintiffs' lawyers so long as they're willing to pay for it. So I think that's an interesting way to look at it. That I'm pushing it back to the original gatekeeper, just with a purchase price attached. I don't know much about Daubert, sadly. This is another, along with the PSLRA and FOIA, I have to learn something about maybe to see whether there's lessons that I can take away from that context. I think you're absolutely right that at the same time, computers have made it more burdensome for defendants in some ways to respond to discovery requests. Computers have made it easier. You can do search terms in documents. There's various ways to organize documents and what have you. So technology is a double-edged sword. In some ways it's made it more expensive, but surely some of that expense has been mitigated by technology as well. And that should be seriously discussed and considered in a future version of the paper. Are the costs significant to corporations? Maybe Robin can speak to this, but I think corporations think they are. If discovery is going to cost you $1 million, if a case isn't meritorious and you have to pay $1 million every time a non-meritorious case is filed, I think that adds up. When I talk to my friends in the law firms, the corporations seem to be quite interested in lowering litigation costs these days. I think they may see it as significant, but again, I don't know. It'd be interesting to get some survey data on this, or maybe talk to someone like Robin who maybe can chime in.
About getting survey information is that a corporation is not going to tell you how much it costs because it's absolutely contrary to its interests. All that does is just confirm your theory that we're going to try to get these go for discovery. So it's really hard. I mean, we've tried to do that because it is nice to have that empirical information. You're never going to get it out.
Yeah, I think that's right. If the company tells you, on average we spend $10 million in these kind of cases, then the plaintiff's lawyers know, okay, $10 million is the bottom of my settlement demand. So it's going to be hard. I do admit
the Rules Committee did another survey as part of this conference they had down at Duke in May, and I believe that this is the latest discovery survey was conducted for that.
On corporate counsel?
Yeah.
Oh, okay. Good.
And there's a whole bunch of other data from various other people, including corporate counsel and Defense Research Institute, and there's lots of other data. There's data, whether it's good data or not. It's all publicly available.
From the Duke conference?
Yeah.
Okay.
I have the website.
Okay, great.
Yeah, but in terms of what they had in mind when they decided these cases and what drove them, probably most people in the room know it, but I don't. What was in the briefs, what was actually before them. It seems to me for somebody who wants to move the needle on, what's the pleading standard, the Fairman kind of information. Look, guys, you're just behind the times. That would be a very potent argument. Did somebody try to get that across? And my second question, and this is also sort of an input question for the court, and I'll get around to it in a sec. To your mind, who would issue or ordain these rules, discovery rules that have to do with, fee shifting or whatever? The judicial that is obviously a whole framework that the Supreme Court can't do under Rule 8A or whatever other rule it has. Right? At least so far as I understand the process. The Judicial Conference might be perceived as completely incompetent to do anything, because anytime you want to do anything, somebody yelps, "That affects my substantive rights," and you're dead. The Congress will just say, "Why can't you just order your own courts? Why is that our problem?" So there really isn't anybody around, and I wonder whether that experience over time might have prompted them to say, it'll never happen, even if the Chief Justice Rehnquist was a stickler for the Judicial Conference and good order. We know it's not going to happen. Therefore, let's do it this way. And furthermore, even if we all agree that there might be some more rational way to do it, it's not going to happen on this planet, and so therefore we're going to take a meat axe to this. We know fully well that some good complaints go by the boards, or might, under this standard, but it doesn't really matter so long as the ratio of crud to good lost cases is sufficiently high, and that our gut tells us will probably be the case, and so here we are. And that strikes me as sort of a perfectly sensible institutional way of thinking about this problem.
Yeah, I think that's a very interesting analysis. You could say that maybe the court was convinced that it was too difficult to get something through Congress or the Judicial Conference, and so it had to do it on its own. That's a very interesting analysis. I think it's perhaps more compelling with the conservative justices. I'm not sure about Justice Souter and Breyer thinking that kind of way, but I think it's a very interesting analysis. Now, when it comes to a fee-shifting rule, I think it would probably have to come from Congress if we wanted to go down the fee-shifting route. I don't think they could amend the federal rules to set forth fee-shifting. I think if you read Marty Reddish's paper, I think he kind of implies that you could do it through the rulemaking process, but I don't think most people believe that. I think that most people think that would have to be congressional reform, and it's so hard to get anything through Congress that it does add some credence to what you say. The Supreme Court could make change much more quickly and effectively, and maybe could be the only one to make this kind of change, given some of the gridlock that you would have. It would be very difficult to get something like this through the Judicial Conference because of there'd be a lot of objections from the plaintiff's bar, and so there could be some truth to that. I don't know what was in the Twombly briefs. To be honest with you, I'm not sure how they framed the arguments, like, we need to update what's going on or not. I think, despite the fact that Souter retired the Conley v. Gibson standard, I think there was a real effort on the part of the court to pretend like they weren't doing anything different. And that's usually the most effective way to frame things to the court, is to pretend like no one's doing anything different. And so I would speculate that's probably how it was framed, rather than you need to change things because discovery's changed. It was probably framed like, just keep doing what you've always been doing. and so that's what I speculate, but I've not read those briefs in a long time, so I can't remember.
On the catch-up theory about the court doing this to kind of catch up with the practice of trial courts, an anecdote which leads to a question. A week or so ago, Justice Sotomayor was here for a Q&A with students, and one of her answers about the docket, she said that in her first year on the court, she has been very aggressive at pushing for certain cases that matter to trial courts in terms of their day-to-day practice, and she's done this because she's the only one on the court who has a clue what goes on in the trial court, because she's the only one that's been a trial court judge
or a trial court litigator.
Yeah, well, I think Alito may have had some trial court cases as a prosecutor, but in any event, but nothing comparable. Nothing comparable, right, on the civil side, certainly. So, she has said publicly that she cares about making the court pay more attention to the effects of its decisions and the sorts of questions it answers on day-to-day practice in the trial court. So it leads to the question, if your speculation about why the court would do this, and it was in part catching up with what the trial courts were doing in the trenches, because they are faced with these complaints and stuff all the time, is a test of that theory. And, who knows when we'd know whether this actually took place. What Sotomayor does on these sorts of questions, and would that theory make her role on the court particularly important? Because as you speculated, Chief Justice Roberts had more awareness perhaps of the realities of complex civil litigation for the last 10 or 15 years than his colleagues when he joined the court. Justice Sotomayor has far more knowledge of, both as a civil litigator and as a judge, of the realities of district court litigation than probably everyone else on the court combined.
No, I think that's a great point, and I think that I would expect her to be somewhat influential with her colleagues in these types of cases going forward for the very reasons you've stated. I mean, again, she's really the only one with district court experience, and so I would expect that. And it will be interesting to see what kind of decisions she makes in the run of cases in this area. And it would probably be interesting to go back and look at what she did when she was a district court judge or when she was on the Second Circuit, to see if she had any pleading cases and whether she was one of these lower courts that was using heightened pleading standards. I think that'd be very instructive, Jonathan. Good point.
Right.
Just a quick question and a related comment. One of the points that you made, and one of the basic points on why Twombly isn't that big of a deal, is that it's catching up. I'm wondering, wondering aloud, if the dynamics, though, of the Supreme Court clearly stating something and ratifying it in a very public way nonetheless is likely to affect, even just in an atmospheric way, how district courts apply those standards going forward as opposed to beforehand. And the related comment is that I think you mentioned at one point that I remember from the paper that there hasn't been any noticeable change post-Twombly in dismissal on the pleadings. I wonder if that really shows much, right? Because, of course, the people drafting the complaints are aware of it as well, and so you have the feedback problem, and maybe it gives us some very rough sense of whether there's been a dramatic overnight shift. But if you go any further than that, there's so much that could explain that rate that it's hard to rely on that to say it hasn't had any impact.
Yeah, no, I think that's a great point about the weakness of the empirical methodology in this particular context. Again, there's the law in economics which would tell us that we would expect win-loss rates to basically be 50-50 in every type of situation, and what's going to happen after Twombly is people are going to file different complaints, bring different kinds of cases, and people are going to file motions to dismiss right up to that 50-50 edge again. And so you're right, it's hard to tease out empirically whether there's any before and after effect. The best way to do it, I think, and I think some of the studies do this, is to take cases where the complaints were filed before Twombly and where the motion to dismiss is ruled on after Twombly. So you have the pre-Twombly complaint. So it was not filed, the case was not selected based on Twombly. And look at those success rates and compare them to the motions that were decided before Twombly and see what happens. I think some of the studies do that, but I'll have to go back, frankly, and take a closer look. I think that's the only way you could do it with credibility. Would you agree, Brad?
Yeah, I mean, my one reservation would be that the judge would also know that they didn't know of Twombly when they filed the complaint, and even if the judge is nominally applying Twombly, there's got to be some psychological impact on the judge not subjecting the complaint to the standard that the plaintiff couldn't have possibly known of.
So I guess it's impossible to know then.
In the securities area, because of the heightened pleading standards for scienter, what the plaintiffs have been doing is finding confidential witnesses
One of the other things in the securities areas that makes the very expensive discovery process more difficult is paid for by D&O insurance. So it's sort of spread out among the whole industry, which just adds to the complication. Well, one of the things I would say in listening to this is, I feel like in talking about Twombly as a discovery correction method, we've sort of taken the bait. What we realize, I think everybody here realizes, is it cuts off cases that have low discovery costs, right? It doesn't automatically cut off high discovery cases. It also is not clear that it cuts off high discovery cases, right? I mean, we have one case where it does cut off a high discovery case, but where all of those e-discovery abuses are, anecdotally, they may all still be there because they may fulfill the pleading standards under Twombly. So what I would submit is whatever problems we have with discovery exist before Twombly and exist after Twombly, and we're going to have to solve them through a different method other than Twombly. What Twombly does do, though, which is the same thing that happened with the strong inference language in the PSLRA with the securities cases, is it's simply a docket clearing doctrine. The docket clearing doctrine. In the securities area, if you can't plead a strong inference of scienter, now realize scienter is intentional behavior, right? How do you know whether the parties acted intentionally from facts that you can gather in the marketplace before you get to actually ask them what they were thinking, right? This is intent. It's what's going on in their head. Yet nonetheless, Congress said if you can't show strong inference of intentional or reckless behavior, your case gets dismissed. So it's just a method of clearing cases out of the federal system. I would submit not based on the merits at all, just reduces the number of cases because you can't meet that high pleading standard. So I think the issue with Twombly is this the right way to clear the dockets, right? I mean, maybe what we should be doing is eliminating diversity cases, or something like that, and cutting down on the number of cases that the federal courts have to hear, and that might be a more equitable or merit-based method of doing it. I wonder whether Twombly really is cutting off the right category of cases that we're trying to keep out of the federal courts.
No, I think I agree with your intuitions wholeheartedly, that Twombly is both perhaps hopelessly over and under inclusive, and it just does not do a very good job of doing what the court wanted to do, which is why it made me think, well, maybe there is a better way to control access to discovery, at least, through a fee-shifting rule. But I think I share your intuitions that a lot of these expensive discovery cases are still going to go forward. And a lot of cases where discovery wouldn't have been expensive are probably not going to. And perhaps there's not going to be much of a correlation between what is in court and what we think should be in court as a matter of discovery costs. So I think I share your intuitions there, which leads me to ask the question about fee shifting or some other mechanism. Now, to reconceive the decision as a docket clearing mechanism, and then ask, is there a better way to do even that? That's interesting. I hadn't really thought of it in that way, but that's something I'll have to think more about. That's an interesting way to conceive of it. Thank you.
If Twombly is about to be the most cited case of all times, articles about Twombly are about to be the most written articles of all time. So let me begin with a suggestion, is that you take out most of pages 1 to 22 of your paper, because you say them a little differently in different pieces than lots of other people, but they're all saying them, and by the time that this gets into print, everyone will have said them. I think that the interesting questions are what you have in pages 22 to 27. And the people, if I see another Twombly article, I'm not going to read it. If you say, you start an article, what should we do to deal with the problem identified in Twombly, somebody might read it. So that's my first suggestion to you, because no one will read this. And people, I don't want to argue with you about some of your premises, but the second point is, I share and I raised it at the Duke conference, the doubts about the data on cost. I could not get an answer to the question, did you include lawyers' fees in the data? Nobody would tell me whether they did or they didn't, and if they did, how did they get the fees and so forth and so on? What did they include in their costs, and how would they see to the pants? Second. Third is, it is clear that there are many, many cases that show up in the federal court system in which there is little or no discovery, either because they're administrative review cases, they are prisoner cases, there are Title VII cases in which there is little discovery, there's no cost of discovery. On the other hand, it's clear that there are some cases in which the costs are enormous, and therefore, this is a situation in which average costs are completely meaningless. And to the extent that Twombly tries to deal with something that purports to pervade the system, it's clearly the wrong device, and you're definitely right about that. And so I encourage you to look at solutions. I don't think that fee shifting is prohibited. For years, we've had sanctions under Rule 37. We've had sanctions, shifting discovery costs. As long as it's limited discovery, I don't think you're going to have a problem with the Rules Enabling Act or the American rule. But certainly, you want to talk about that in the part of your paper. And the real benefit of this is to get people thinking about concrete solutions. The difficulty with the Duke conference is that a lot of the people who said, well, we don't think Twombly is the right solution, but we think there's a discovery problem, didn't offer ways about it to deal with it. And so my suggestion is you could start thinking about this, and in fairness, it's not just the Supreme Court who issues these rules. The rules process is dictated by Congress. They have to have an advisory committee. They go through a long and elaborate process in which lawyers from all kinds of entities, public entities, plaintiffs, defendants, nonprofit organizations, comment about it. And in that sense, it is much better than the Supreme Court deciding this by the seat of its pants with an all or nothing, this is what we decide thing. So there is value in the process. Congress has mandated it, and your suggestions would be something that I know the Rules Committee is going to look at this. I don't think there's going to be a statute that's going to put this on hold, and we may never know what the impact of Twombly and Iqbal is, because there are too many variables to take into account, and I don't think you're ever going to get an answer to this. But I encourage you to think concrete solutions, not that anybody's going to adopt them, but at least getting people thinking about the ideas and dealing with the problem about what the Rules Committee can and cannot do would be very valuable.
Well, and I really appreciate those comments. I think they're outstanding, and I think I agree with everything you've said, except for maybe your very last point about whether the judicial conference process is required before the Supreme Court can promulgate a new rule. But let me just start at the beginning. So I think you're right. Again, which is why I wanted our discussion to focus on the last 5 pages of the paper. I think that is the intellectual payoff of this particular project. But when you're at a conference on the Roberts Court, you have to throw in pages 1 through 22 in order to get your travel expenses reimbursed. And so I did. But I think you're right. I think the intellectual movement is fleshing out the last 5 pages. Well, God, I hope the FJC survey's discovery clause include lawyers' fees, because otherwise I don't know what they are including. So that's something I'm going to have to look into. I assume they did. I'll have to go back to the survey and try to figure out exactly what they asked the lawyers to report there. And I agree with you wholeheartedly that in this context, average costs probably, or even median costs probably are meaningless, which is why I think we agree this all or nothing approach, one-size-fits-all approach is meaningless, which has made me think maybe a more tailored approach, like fee shifting, would lead to better outcomes than trying to apply the same approach to big cases and small cases. The same access to discovery to big and small doesn't make sense. I think you raised an excellent point, and so I should amend my prior response to Michael. Fee shifting is already in the federal rules, and so presumably, if that suggests that it does not violate the Rules Enabling Act, presumably the rule makers could adopt a broader full fee shifting provision through the rules. I think you probably must be right about that.
I mean, at some point, it might tip over too much.
Maybe, but just discovery maybe
it's likely to get through is probably okay.
I think that's an excellent point, so I want to amend my prior statements.
That's logically true.
So again, Alan, I do want to talk to you more about this, I guess, offline, and that is when I read the U.S. Code, it says the Supreme Court shall promulgate the rules, And then another section says the Judicial Conference shall prescribe a process to consider amendments to the rules. Nothing says the Supreme Court has to wait for the Judicial Conference to do anything before promulgating a rule, in my reading. But maybe I've misread it, and I'm happy to talk to you offline about that and have my perception corrected.
Well, I mean, put it this way. I think that the rules committees themselves and the Judicial Conference, not to mention the Congress, would be very unhappy. And if the court actually purported to just issue a new Rule 8, my hunch is that Congress would come in and stop that from going forward, if for no other reason than that they appear to have violated what has become the norm for the rulemaking
It's certainly
process.
the norm, yeah.
It is certainly the norm, and I don't think that they would do, I don't think, I mean, after all, the chief appoints these people on the Rules Committee. For him to just simply turn around and people say, we're just disregarding your entire process, you become completely irrelevant, and it would be a little hard to do.
I agree, and I just want to state for the records, I think I say in the paper, I think there's great value, procedural value to the process, and I think it would have been better to make a change like that through the process. I will say what I find somewhat perplexing, maybe not. Maybe it's not entirely analogous, but the Supreme Court has no problem vetoing what the Judicial Conference wants to do. You know, there'll be times when the Judicial Conference, after this process has gone on for years and years and years, and they want to amend the rules, goes up to the Supreme Court, and the Supreme Court justice for the first time sees this proposed rule and doesn't like it and throws it out. I remember when I was clerking, they threw out an amendment to the rules of criminal procedure that would have allowed two-way video testimony in criminal cases. No one in the Supreme Court was even aware that it was there's under consideration, and it got to the Supreme Court. Justice Scalia said, oh, I don't like that one bit. No way in heck we're going to do that. And that was the end of it. So the Supreme Court has no problem stopping things from the conference. And so I guess I'm not entirely clear why they can't add something at the last minute of the process. They can take something out at the last minute. But your point is well taken. It is the norm, and it certainly violated the norm in this case.
I just want to raise two thoughts. One is something I think we just take for granted, and that's the trust in attorneys to do discovery. We kind of look at it as an outsider. It's kind of amazing in some ways that you trust someone representing the other side to give you all the information that will help you in your case and may in fact seal their doom, right? And so one thing that you might get if you start having the other side pay is them getting more involved in that process, or at least wanting to get more involved. And it will probably start with them getting more involved in how those fees are calculated to begin with. But you know, I could see down the road that, hey, well, I'm paying for this. You know, I have this mic. I'm paying for this microphone kind of thing. I want to, you know, have a little more say in how it's being used. The other point I wanted to make was just in terms of the frames that people bring. It's interesting because you kind of raised this by talking about the frame that Chief Justice brought to it by having done litigation recently, and then we were just Jonathan was talking about Justice Sotomayor. I think that's the worry of a lot of people, is that you're going to have judges bring their frames to this plausibility analysis, right? And that you're going to have that kind of influence more openly, right? It was a concern about the summary judgment, you know, the reasonableness determination. And you might want to look at some of the research like the Kahan, Brayman, Hoffman study of, I can't remember the case, I think it was a criminal procedure case involving video of a police chase. The different perceptions that people had. The justices believe there's only really one reasonable perception that people could have of what happened, but they did a study where other people, you know, the majority found it to be one way, but there was kind of a sizable minority of folks who looked at what had happened and had a different view of the chase. So you might want to kind of think about that in terms of why some people might be concerned about the plausibility analysis, the judicial frames. I mean, if you're saying that the fact that, you know, the Supreme Court changed its course in this kind of sweeping fashion just because one justice had actually litigated in the past 20 years, think about the impact that, you know, the experience of relative judges, you know, are they a prosecutor, are they, you know, do they come from defense, do they do civil litigation, where they work, you know, if you look at kind of the sociology of the judiciary, you could say, well, you know, boy, we might really worry about how their frames affect this plausibility analysis. So
I think both those points are excellent. I think you're right. A lot of people are concerned about the malleability of the plausibility test and how it will allow people's priors to dictate the outcome of cases. I think it is a concern, and I think a more automatic rule, like a fee-shifting rule, could mitigate some of those concerns over malleability. And I also love your point, actually, about how a fee-shifting rule, at least where costs are shared in some either ex-ante or ex-post sense, might encourage some more collaboration among the lawyers in plotting out how discovery is going to be done. I think that's an interesting point that I hadn't thought of, that maybe some positive side benefits to sharing costs in terms of collaboration and more efficient discovery plans, and maybe more collaboration overall, and having civil litigation being a little more civil in some respects. So I think that's a very interesting observation, and I appreciate it.
All righty, well, we're just about out of our time on, I don't have any grand closing remarks, but one thing I would ask for everyone is for feedback on the program, the format, the substance. Is this the sort of program we should do again? Is there room for additional conferences in this theme or not? And if we were to do something, what did we do well? What could we or should we do differently? We try to learn from these programs, not just substantively, but also how we can do better programs. So any feedback any of you can provide in that regard would be very much appreciated. I also just would be remiss if not once again thanking all the folks that helped make this possible. Nancy Pratt, who you all have received many emails from, but also Alice Simon and Jared Gregory are really indispensable for all the stuff all the programs that any of the centers here at the law school put on, and they should be thanked heartily. Ben Oster, who was a research fellow for the center over the summer, and helped me with some of the background research and figuring out what it is we were going to try and do here was very helpful. Certainly the AV folks that have tried to record our proceedings for posterity so that we can share our insights and our discussion with others are due thanks as well. Certainly our four paper authors, and personally, let me also say all of you, because I certainly had an interest in putting this program on, but in the last 24 hours or so, learned a lot, both about these specific subjects, but also the general theme of trying to understand this court and what it's doing and what it's not doing, and having all of you here participating in this conversation certainly made that possible. So also thanks to all of you for participating and making this happen. And that's all I have. Again, there are lunches outside, but thanks again for coming. And hopefully, if we do this again, many, if not all of you, will be able to come back. So thanks again.
Thank you. Thank you.